Ross Kemp on gas. So he goes around the world. He goes around the world and visits various prisons. Yes, so you've got to see the worst goes to Brazil, goes to Sao Paulo, America, in the series. The worst gangs, the worst prisons, Paul's new. Says Paul's not the word.
Oh, I didn't know that. Oh, okay.
Please don't let that know.
I don't know. Okay. That's fine. Oh. Okay. 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 So. We're about to start court now. Yeah, prepare it and then send it to me. Yeah, then I can do it. It's A flat, A-P-L-A-T-T, P-L-A-T-T, L-T-T, Yes, yes. Okay,
My lords and lady, you posed a question to me. I had a look at what happened, and whilst it is so that the permanent stay was scheduled for hearing on the 25th of August, and the third respondent had to file its papers by 18 May, I think, that was probably not the urgency at the time in February. What was the position? And that arrangement had fallen away, because what the situation was is on, I think, the 12th of January, the Supreme Court of Appeal gave the judgment in the matter of NDPP versus Zuma. And that was the matter dealing with the fallout from Judge Nicholson's judgment. So that was appealed in January, and the prosecution filed their papers also in January, and we had gotten leave from the Constitutional Court, and I think heads had already been filed and so on, and that matter we were just waiting for an urgent date for the Constitutional Court around about February, March. We were waiting in those months. We didn't, and I can't recall whether we had been given a date, but if there was urgency about it from a litigation point of view, it would have been that. And as a result of this decision, the Constitutional Court was advised that dispute had become academic.
The applicant in the papers alleged that Mr. Haley was informed about the decision to discontinue the following day. Do you agree with it?
Sorry, man?
The decision not to prosecute. It stated in the papers that they were informed on the 2nd of April.
That may well be so.
Do you know how was the information conveyed? Was it in writing or orally?
I would not know that.
Fine. Thank you. Okay. You may proceed.
And if I can just say to my lords and my lady, from the record, it seems that on the 6th of March, Mr. Maché told the people in the NPA that he would like to be able to provide a decision by the 1st of April. You will find that on page C82 and 83. And the 1st of March was approximately 6 weeks after the representations. We simply make the point that as far as the 2003 accusation was concerned about the meddling by Mr. McCarthy and Mr. Milcar, we firstly want to say to my lords and lady that despite any suggestion to that effect, the 2009 decision of the SCA, that is reported to 2009 2SA, page 277, that is the judgment delivered by Mr. Justice Harms. The veracity or whether there was political meddling prior to 2007, prior to and as part of the Picoli decision and Milcar McCarthy decision, that was not decided in that matter. I can simply say to you in paragraph 14 of that, the court says, more particularly, this aspect of a judgment is not about whether there was political meddling in the decision-making process. It is about whether the findings relating to political meddling were appropriate, or could be justified on the papers. And, my lords and ladies, if I can just quickly tell you the context. Those were cut and paste allegations from the 2005 proceedings. And the contention was, which the SCA rejected, was, look, that created the background for the refusal by Mr. Maché in October of 2007 to hear representations, because Mr. Halley wrote him a letter on the 10th of October saying, we want to make representations because we hear that you are reviewing these matters. And Mr. Maché wrote back on the 11th, no, we're actually not reviewing these things, so there's no need for you to make representations now. And the argument was, but hang on, when you, even if it was now, as they say now, a formality, when you were looking at reinstituting the charges, why didn't you give us, even at common law, just a hearing? And those allegations of political meddling was put up to say, but in the light of those allegations, why wouldn't you want to hear us? And the SCA said, no, you either had a right to be heard or you didn't have a right to be heard. Those things don't come into that question. And that is why the judge says, well, this is not about whether that was true or anything like that. It was not relevant to the point that you were really trying to make in the case, and therefore they were struck out. So there was no decision on whether they were sound or not. If, as far as the 2003 situation is concerned, it must be borne in mind that its common cause was that public announcement as to the prima facie case against the president, and that was against the advice of the team, and the public protector. And much later we learned that the public protector's findings are actually binding. And those findings said that the president's rights were violated as a result of the announcement and the manner of dealing with the 2003 charges. And we simply say, well, we did not see any review of those proceedings. If I may just briefly address you on the law. My lords and ladies, I have undertaken to my learned friends for the applicant to provide you with a copy of the case that they referred you to, Maxwell's case. That is a 2009 reported decision in the UK. In 2011, there was another decision that I will give you. It is the decision of Warren, W-A-R-R-E-N, versus the Attorney General of Jersey. And that case basically deals with, and it seems to me still reflects the current law in the United Kingdom. And it's an interesting case with an interesting outcome, where the facts were briefly that the police authorities asked various countries through which a drug smuggler was going to travel whether they could fit a tracking device to his vehicle and also an audio-visual device. Some of the countries said, no, you can't do it. The police went and they did it. They put audio-visual recording device on it, and the person was caught and he was prosecuted. According to the reported judgment, you'll be interested to see that he had apparently earned 142 million British pounds out of his past drug smuggling activities, which is a mind-boggling sum when you multiply it with 25. And the trial judge, on hearing a permanent stay based on this abuse, refused it. The Court of Appeal said, look, whether you grant a permanent stay or not is a question of broad discretion. It is not so that there is a specific but-for category, like the false extradition and kidnapping type of cases. They part of a general broad discretion that the trial judge has. In this case, although the police acted gravely unlawfully in putting this device on the vehicle, they were upfront as far as that is concerned. They came to court and said, well, we did it. Have a look whether you want to admit the evidence or not. In those circumstances, the court, mindful of the fact that the bar for permanent stay is very high, said no, they, although a decision granting a permanent stay would have been perfectly understandable, they're not going to interfere with the trial judge's discretion, even if this is a but-for case. It does not, it depends in cases of this category, where you're not dealing with trial prejudice. It deals with a question on whether the interest in the criminal justice system requires such an order to vindicate it. And they said that is the test. And my lords and ladies will see that it's some of the same judges who sat in the earlier Maxwell case, and they explained some of the things that they said in the Maxwell case, where they seem to suggest that there is a but-for category of cases where there must be or there is a real harm to the accused as a result of an abusive process. Mindful of the fact, of course, that they drew this distinction in the latest case at the expense of the accused. They said, well, just because you fall into that category, you're not automatically entitled to a permanent stay. Broad discretion, in your case, it is 50-50, but the decision of a trial judge stands. And we'll give you that, my lords and ladies, we'll give you that Patel and early cases that we've referred to as well, and I'll give you about a 2 or 3 page summary, if you would want, from probably the leading textbooks in the UK on this type of case. I think 2 or 3 pages do not infringe copyright, my lords and ladies.
That would be appreciated if you can get a
summary. And I will put it together and make a copy for each of the justices.
Now, with the summary, just give it to your colleagues.
Yes, I have given them copies of. If I may then just deal with, if one looks at that element that I've spoken about, that it's not necessary that the accused has to show an infringement of his rights. It is in the first place not about his rights, it is about the integrity of the criminal justice system. We have made reference from, and a case from the South African jurisprudence which is often cited in these cases, even in Latif's case, is the case of State versus Ibrahim. You will recall that was the 1991 appellate division decision where the police virtually almost kidnapped the accused to come into the jurisdiction of the court, and he was charged with certain offences and he was convicted and went on appeal. And the Supreme Court of Appeal, as I would now be known, said, well, if you come to court with dirty hands like that, we are not going to uphold the conviction, and it doesn't matter about guilt. He is in fact outside our jurisdiction, despite that he stands in front of us. And that case has been very influential in the overseas jurisdictions and the cases where that has happened, some of them also involving South Africa, where we have put people on planes, or allegedly put people on planes, and those issues are covered there. But if I may just draw to your attention, if one looks at the policy of the National Prosecuting Authority, when it comes to the factors that you consider, they don't even mention the strength of case, and there's a reason why. Because strength of case is presumed. If you don't want to prosecute somebody because you have doubts about whether you've got a strong case, you decide not to prosecute him on that ground. But if you consider that there are sufficient grounds on the facts for and evidence for prosecution, then you look at the other factors, mindful of the fact that you've got a strong case. And that is why I have put the proposition also to my lords and lady that indeed, at the stage that you get to the policy factors and the integrity of a criminal justice system, it is no longer really about how strong is the case against the accused. You assume that you are going to prove it.
As you are talking about policy, I'm looking at the draft letter D7, on D8. There is a statement and allegations which says that Chapter 4, Paragraph 6 of NPA Policy Directive provides that where the prosecution is confronted by opposing versions, it should refrain from making credibility finding based on written statements and should rather refer the matter to trial. What do you say about this? Because in the case before us, there are opposing versions as to the conduct of McCarthy and Muka. Muka said no, everything was done in good faith. So was it not better, as it is stated here, that it's reflected in the policy that the matter should rather be referred for trial so that the court can deal with these issues in detail?
My Lord, can I first give you what I would suggest would be the technical answer to your question? And that is, how is that going to be before the court from the NPA side? They can't bring it before the court as part of a criminal case. It is not, that is not a list. And if you look at the freedom under law case, Judge Brandt says that. He says the decision to prosecute doesn't form part of the trial proceedings before the court. That's why you can bring a separate application for that. It is, I mean, if we started a criminal trial and we said we put everything in dispute, the prosecution would call its first witness. It would not call Mr. Muka. There's no way that they were going to call him. And how is he going to get into witness box and this resolved unless we decide to bring a permanent stay application? How does that help the NPA? So that is from the technical side. From the other side, my Lord, on the evidence before you, there is no evidence on oath to say that the inferences drawn by the NPA and by Mr. Hofmeyer and by Mr. Maché, and in fact by Mr. Downer, as to what was intended to be achieved between Mr. Muka and Mr. McCarthy, had any proper purpose.
It's about the versions.
about the versions.
Yes.
But Mr. Nuka hasn't put up a version as far as I know, my lord. He has made certain statements, yes, but he hasn't dealt with any of the accusations, and the point is, there is a simple point. In terms of Section 41(6) of the National Prosecution Authority Act, you're not supposed to discuss these cases and the prosecution and the information you have about the cases with somebody outside the National Prosecution Authority. Now, why was this being discussed at all between Mr. Nuka and Mr. McCarthy?
Okay.
There is no gainsaying Mr. Hofmeyer's evidence. There's no gainsaying what Mr. Maché says. There's no gainsaying what Mr. Downer says. In fact, Mr. Downer gave a lecture, if you recall from the papers, where he says, well, listening to that, it seems very clear what is going on here. What he says is going on is that they're trying to manipulate the service of the indictment to get a favorable result at Polokwane. So I do not, there is certainly no bona fide dispute on the papers about that. And for that reason, in our submission, it is quite clear what this was about. If I may then just proceed to another issue, and that is the withdrawal of the charges. And Lords, if I may just hand up to you a copy just to get the chronology correct. It is just a one paragraph that says that the date was actually the 8th and not the 7th, as appears in the papers of a withdrawal. But if I may just say to my lords and lady, that the withdrawal of charges is indeed a separate legal act from the decision to discontinue charges. It may well be that the one informs the other, but that issue was not raised on the papers, and it was not part of a release. And my lords and lady, one can understand also why, because this, if you will recall, this application by the DA, the original one on the applicant, was drawn in part before the announcement. It was drawn in anticipation of the announcement. And at the time that they issued it, of course, the charges weren't withdrawn as yet. So they could have asked for an interdict staying that, but they did not. And may I say to you what the basic argument about that would have been? If we had gone to court in the province of KwaZulu-Natal, because that is where the charges were and that is where they were withdrawn, the court would have said, well, what's happening in the matter? And if a prosecution said, well, you know, we have sort of decided not to carry on, but our situation is being reviewed, the court would say, well, what has that got to do with me? You've got an accused in my court. Are you saying to me that he must come to court every month? What's wrong with you? Why don't you withdraw the charges and then charge him again when the time is right? I have no doubt that that would describe very accurately how a judge would deal with a lingering thing for, as it turns out, 7 years. And say, no, you're on bail, you must report, you don't have to report, you must come to court on this day, etc. Why? There's absolutely no reason why the accused should be put through that. So,
Inspector, was he scheduled to appear on the 8th?
yes. No.
In the normal course of things?
No.
He wasn't.
No.
So the application on the 8th, I mean the appearance on the 8th, follows the decision on the 6th.
Yes.
And you say that no one brought an application to interdict.
Yes.
And is there any mention made in the announcement that there will be this withdrawal on the 8th?
No.
Yes, because I mean, if one would say that there was no interdict, how would one have known that there would be an application as soon as the 8th, which is about the third day from the announcement?
There wasn't an application, my lord. What happened is that the prosecution set the matter down. Advocate Steinberg was in court. And on that day, the charges were put to, were not put, the charges were withdrawn in court.
Yes,
And
but then the applicant in this case, for example, would not have known that there will be this appearance in court for it to bring an interdict.
Well, my lord, with great respect, the applicant could readily have found that out.
No.
Of course it could have found that out. It could have asked the NPA, when are you withdrawing charges? And saying, and it would, I would have thought it would be standard if that is what you want to achieve, to say, look, as interim relief, we don't want the charges withdrawn until this matter has been decided. I mean, that is normally how one would safeguard you against such a step if you intend such a step to be part of your relief. But may I say to the court, what did it really matter to the applicant at that stage? If I had a very clear and obvious case, they could have been in this court in a month's time if I said, well, we have everything at our disposal, this is what happened. And it would have been reversed, and what would then have been had to happen? The charges would just have to be put again, depending on the basis for the decision to set it aside. There was no harm in withdrawing the charges if you could bring them again. And you will see in the freedom under law case, the court says that, in fact. So the only point that we make is, well, if you wanted that relief, you should have asked for it at the time. It has been withdrawn. That has certain consequences. They have consequences as far as bail, refund of bail, all those issues are concerned. Those are the normal consequences. And the submission is, I don't see any court amenable to keeping an accused on the line in a case where the NPA says, well, we've actually decided not to prosecute, but because somebody has taken us on a review, you must come back every couple of months to appear in court. No, my lords, that is not how a court would have dealt with it. So it was withdrawn, and that is not covered by the order sought. And the only point we make is, obviously, if they wanted to cover it, they would have to cover it in the form of some kind of interdictory relief on the 7th of April. It wasn't withdrawn then, and I accept it. I may not have known when it was set down, but certainly, in our submission, if you are against the respondents in your final order that you grant, it is in our submission fairly clear. If you then find that there was not sufficient attention paid to certain things, then obviously that must be done now. It can't be that the third respondent had lost his rights to make representations and to have his representations considered. If you say they did not consider them properly for some reason, then they must do so. That is what must happen there. I don't see...
Your argument. It is clear from the notice of motion that the notice of motion is silent in respect of the charges that have been withdrawn.
Yeah.
So what? What was the problem with it in the case before us?
No. If my lord simply say, if you find for the applicant that decision is set aside, then so be it, then they got what they asked for. But that certainly, there seems to be some suggestion in their heads that now means that the charges are reinstated. What we simply say that can't be. That is not what you asked for. And it's a simple question of what did you ask for? You can't extend it to something that you did not ask for. And if I can give my lord the analogy of what I have in mind. My lord, one often asks for a tender award to be set aside. But whether the tender award is set aside is not decisive of whether the contract concluded pursuant to the tender is set aside. You will have seen the decisions that Mosemi and all those decisions would say, the one does not follow the other. You may declare that the award was unlawful and invalid. But you may, for example, for policy reasons and pragmatic reasons say, but for the contract has gone so far, I'm not going to set aside.
So are you suggesting that they should amend their notice of motion?
If I wanted to amend it, they should have done so a very long time ago. That is the submission I make. And if I had done so, we would have dealt with that on affidavit. We would have raised issues about that. There are a whole number of issues that would have become important, including the indictment of a sitting president. That is not an issue before you, because that is not the issue. But if that is the issue, then surely we're entitled to raise
those
that.
issues would be dealt with after they shall have been raised, and we should not concern ourselves too much with them.
My lord, no more submissions about that topic shall come over my lips. Lord, if you will just bear with me.
Yes.
My lords and lady, unless there's anything else, those are the submissions we make. We would ask for the cost of 2 counsel. That is what I understand the normal cost is in a matter. Thank you, my lord.
Thank you very much. Thank you.
As these court justices, justices, the applicant summarizes the review.
Just maybe for the sake of order, I see the other counsel or legal representatives were before the microphones. Can I check with the stenographer? Can you record properly? If Mr. Omar is standing there, would you prefer that he comes there? Is it fine? Okay, you may proceed, Mr. Omar.
As you please, the court, Justice Withdrawal. Mr. Justice Withdrawal, and of course the other justices, the applicant summarized its relief it is seeking in this proceeding on page 434. Now let me do this, justices. Before I continue, may I please ask judges to allow me to hand up a document headed oral submissions of Amicus reduced to writing. This will be very helpful for the court to follow my submissions as expeditiously as possible.
On the documents sent to us when we requested the time schedules of the arguments, it was noted that you'd address us for 15 minutes. Is it still the case?
No, in my practice, I said approximately 1.5 hours. But I will ask Judge to give me 45 minutes. I'm confident I will be finished in 45 minutes with judges guided by my written submissions.
I'll give you the 45 minutes.
Thank you, On page 434, the applicants summarize the relief they bring forth in these proceedings as follows. In the main case, the DA seeks relief challenging the lawfulness of a decision taken on 6 April 2009. It doesn't stop there. It says the DA, the applicant, challenges a decision, I want to emphasize the word decision, taken on the 6th April 2009 by then incumbent...
Excuse me for a moment. Excuse me. Yes.
I'm so sorry. The cameraman said that I can't hear Mr. Anwar on the camera. So he needs to stand in front of the mic.
You don't know. You can adjourn shortly, let him sort it out.
Yes, that's okay. Okay. I'm told that when you are standing far from the mics and your voice is not captured properly, we'll just adjourn for a few minutes so that the microphones can be placed properly, or maybe you can move closer to the microphones that have been set already. We'll adjourn for some few minutes.
All right. Number one, Chief. C'est bon, vous. Sorry, but you test. It's okay.
You may proceed.
Thank you, Judge. Judge, I've handed up a document headed Oral Submissions of Amicus Reduced to Writing. Now, with reference to paragraph A on page 2 of that document, the relief prayed for by the applicant in these proceedings is summarized as follows. In the main case, the DA seeks relief challenging the lawfulness of a decision, I emphasize decision, taken on 6 April 2009 by then incumbent of the office of the first respondent, Advocate Amicus SC, to discontinue the criminal prosecution of the third respondent. Now, with reference to the relief sought for by the applicant, I respectfully refer judges to page 305 of the case NDPP versus Freedom Under the Law, 2014, volume 4, SA, page 298. The SCA in 2014 asked the following question. Then in paragraph 19, the next challenge by the NDPP, who's before the court today as first and second respondents, which was embraced by Advocate Mrebi and Advocate Mduli, related to the reviewability of a prosecutorial decision to discontinue a prosecution. As far as the relief sought for in the full case, the relief appears to be identical, except, as judges will see later, the authority that made the decision or whose decision was reviewed was not the NDPP, it was the DPP. Advocate Mrebi and Advocate Mduli with both Deputy Directors of Public Prosecution. The decision, if one has indeed been made, which I'll come to shortly, has in fact been found to be made. It is a decision of the NDPP. That's the relief prayed for. Then Judge Brandt continues, and on page 3, but before I go to page 308, let's remain on page 305. Judge Brandt of the SCA said the following. The issue arising from this narrow one, the issue arising from this is a narrow one. This is so because it is not contended by the NDPP that decisions of this kind are not reviewable at all. On the contrary, the NDPP conceded that these decisions are subject to what has become known as a principle of legality or a rule of law review by the court. Now, what learned Judge Brandt said, Brandt J asked a question, and this question Judge Brandt answers in the full case. But Judge Brandt deals with the answer to this question he raises himself. Why? Because the NDPP conceded it. The NDPP agreed that these decisions are reviewable. Which decisions? Specifically the decision by the DPP to discontinue prosecution. I want to emphasize that the applicant, no litigant before the court, have even murmured that Judge Brandt erred or was wrong. My submission would then be that accepting stare decisis to be the doctrine in our law today, the findings of Judge Brandt are binding upon this honorable court. Binding for one of two reasons. Either it's stare decisis or it is obiter dictum. As far as the finding on the question which Judge Brandt asked and answered in paragraph 19, I submit it is obiter, but still binding. It's obiter because the question which learned Judge Brandt raised, the NDPP conceded to. Judge Brandt now continues. He says, I'm dealing with the answer of this question on a very narrow basis. Can a decision to discontinue a prosecution be reviewed? That's the question. Okay. Judge Brandt says, I'm dealing with it on a very narrow basis. Judge Brandt deals with extensive English authority. Why English authority? Not because we are surrendering to the former colonial masters, no. We were ushered into New South Africa. Kodesa is there, our constitution is there. It's a product of an agreement, Ubuntu, we settled. We are here now, good. The position in our law, as far as the National Prosecuting Authority Act is concerned, resembles almost identically the position in England. The difference I noted is that the Crown prosecution in England is the NDPP in South Africa. Now, what is the relevance of this? On page 308, judges, at paragraphs B-F, Judge Brandt quotes English authority with approval. I emphasize. In paragraphs B-C on page 308 of the full judgment, Judge Brandt, with approval, says the following. The power of review is one to be sparingly exercised. The reasons for this are clear. The primary decision to prosecute or not to prosecute is entrusted by Parliament to the prosecutor as head of the independent professional prosecuting service, answerable to the National Director of Public Prosecutions in his role as guardian of the public interest and to no one else. Now, Judge Brandt endorsed, approved this view in answering the question the learned judge raised himself. But before I continue, I want to emphasize that South Africa is a constitutional democracy. We are no longer subject to parliamentary sovereignty. Having said that, I continue. Then, Judge, in paragraph D-E, Judge Brandt, with approval, says the following. From all those decisions, it seems to me that in the context of the present case, this court can be persuaded to act if and only if it is demonstrated to us that the Director of Public Prosecutions arrived at the decision not to prosecute Upala. Judges, what do we have here? We have a pronouncement binding upon this court that this honorable court can only interfere and set aside a decision on review to discontinue a prosecution if that decision to discontinue is made by who? The Director of Public Prosecutions. In this case, the DA, the applicant, has not even attempted to demonstrate, and in fact is expressly relying on an alleged decision to discontinue prosecution made by who? The National Director of Public Prosecutions. My submission is, Judge, the court is bound. If my submissions in this regard are upheld, this case is over. We do not have to further endeavor to facilitate the objects of the applicant to have this court pronounced on phantom divisions within the leadership of our ANC on the verge of an election. That's it. Having said that, I will continue. Assuming, by some stretch of the imagination, my submission in this regard is not accepted. Judge, what is being sought here? What is being sought here is, as I've quoted, a review of a decision made by Advocate Amicus, SC, who the applicant alleges set aside a decision of Advocate McCarthy. Advocate McCarthy at the time was the deputy NDPP. Now, where does and how can Advocate Amicus, the NDPP, set aside the decision to prosecute made by Advocate McCarthy? Only one. And this appears in section 179, 5D of our Constitution. Section 1795D, judges, provides the following. the National Director of Public Prosecutions. Now I want to emphasize, our law makes a very clear distinction between the National Director of Public Prosecutions, the Director of Public Prosecutions, the Deputy Director of Public Prosecutions, and the Deputy National Director of Public Prosecutions. This clear distinction made by our law is found in Section 20 of the National Prosecuting Authorities Act, Act 32 of 1998. I'll elaborate, I'll come to that shortly. But on the point I am now, my question I asked is, where does the NDPP get the power to set aside a decision made by the Deputy NDPP? Section 1795 provides that NDPP, we go to D, may review a decision to prosecute or not to prosecute after consulting the relevant DPP. Let's examine that. Judges may review a decision. What is a review? A review is conferring the power merely to confirm the decision made by his subordinate or to set it aside. Okay? Look, with respect, Paja, Section 8 of Paja provides that even a court on review can't substitute or vary the decision. On review, the decision must either be endorsed, confirmed, or set aside. Upera. Nothing more, nothing less. Okay. Now, what is Section 33 is the broad provision in the Constitution protecting the public's right to fair administrative action. Paja Act 108 of Paja Act 3 of 2000 was enacted in deference to Section 33. That's right. That's common code. Now let's examine this. Let's go to Section 8. Section 8.1 of Paja Act 3 of 2000 provides the following. Remedies in proceedings for judicial review. The court or tribunal in proceedings for judicial review in terms of Section 6.1 may grant any order that is just and equitable. Now, if indeed Advocate Mshe did set aside a decision made by Advocate McCarthy, it is clear in terms of Section 8.1 that what will be required of Advocate Mshe is an order. Okay, once Advocate Mshe makes an order, the DA, the applicant, comes to court and asks the court to review that order. We were here for 2 days now. Neither the DA or anyone else in this court once uttered the word that this court is asked today to review an order made by Advocate Mshe. The decision is made by the subordinate, either the Deputy NDPP, the DPP, or the Deputy DPP. That's Section 20 of the National Prosecuting Authorities Act. Now, I'm saying with respect, one, this court today does not have the jurisdiction to review the decision which the DPP, the applicant, wants this court to review. Why I say so? One, I rely on Learned Judge Brunt in the full case. Learned Judge Brunt says a judicial review in court can only take place if the applicant in this case shows the court that the decision to be reviewed is the decision of the DPP. Number two, I further submit that this honorable court does not have jurisdiction. Why? Because the announcement, the expression, the opinion, call it what you want, made by Advocate Mshe, broadcast live on national TV, can never, by any stretch of the imagination, be elevated to an order. No order. This honorable court can only review this matter in terms of Paja. Paja requires an order. If it is suggested that this court is doing the review in terms of the principle of legality, applicant must fail again. Why? Because guided by the principle of legality, this court can only review the decision made by the DPP. That's my submissions on the issue of jurisdiction. Judge, and then I will refer the honorable judges to paragraph B. Judges, I want the court to have regard to section 21, 2, 3, and 4 of the NPA Act. This act and section 20 gives exclusive powers to make decisions to inter alia discontinue a prosecution. These powers are exclusively given to the deputy NDPP, the DPP, or the deputy DPP. And then section 22, Justice Mortley raised a question to my colleague Advocate Epstein. The question raised by Justice Mortley was the following: why didn't Advocate Mshe take disciplinary measures against Advocate McCarthy? The eloquent, correct answer given by my learned friend Advocate Epstein SC was the following. Advocate Epstein told the court that it's only the president who can dismiss an NDPP or suspend him. And that's the reason given to the court why Advocate Mshe did not take disciplinary measures against Advocate McCarthy. Judge, what Advocate Epstein eloquently conveyed to the court is an answer which he gave, which is genuine and true. These proceedings here must adjudicate upon the bona fide conduct of Advocate Mshe. Now, Section 22 of the National Prosecuting Authorities Act unequivocally says that the NDPP will have authority over the deputy NDPP. Okay? That authority, our jurisprudence in this regard is still growing. I submit it could be argued that that authority contemplated by Section 22 will include starting disciplinary measures against Advocate McCarthy. That must still be dealt with in a future upcoming court. The point I'm making as far as my submissions are concerned, it's that Section 20, read with Section 22 of the National Prosecuting Authorities Act, clearly delineates the powers of the NDPP, the deputy NDPP, the DPPs, etc., and lower down. Judge, the NDPP does not have the power to make a decision to discontinue a prosecution. That power is exclusively given to the deputy NDPP and the DPP and below. The power given to the NDPP is one of authority and one of review contemplated by Section 179. Then, Judge, before I continue, I must emphasize the following finding in Freedom Under the Law. Judge Brandt, on page 305, paragraph 19, quotes Constitutional Court authority. He says, found by the Constitutional Court, our Constitution contemplates a single system of law which is shaped by the Constitution. To rely directly on Section 33 of the Constitution and on common law when Paja, which was enacted to give effect to Section 33, is applicable, is in my view inappropriate. It will encourage the development of two parallel systems of law, one under Paja, another under Section 33 of the common law. Who is asking this court today to develop two parallel systems of law? Who? That which the highest court in our land, our Constitutional Court, has described to be inappropriate, the applicant. The applicant is known to boast it wants to enforce, uphold, and respect the Constitution. Here's a case today before this honorable court. The applicant wants and is asking this court to contradict and to asking this court for an order that will emasculate the sanctity of what? Of that which ushered us into a peaceful new South Africa. At this point, judges, I want to say that the principle of legality was reluctantly introduced into our law. In the same judgment, Judge Brown found that a decision not to prosecute and a decision to prosecute is the same thing. Judge Brown said so with reference to section 1FF of PAJ. That this reliance on the principle of legality cannot be used for every decision that is made which PAJ does not make reference to. It is circumscribed very narrowly to only a decision to discontinue a prosecution made by a DPP. So any suggestion, various litigants will say, I rely on the principle of legality, XYZ. No, we are a constitutional democracy. We have to respect our constitution. There are some decisions which will preserve of the NDPP, others in the sole preserve of the President, others in the sole preserve of the National Assembly. Judges, the applicant alleges, and those who allege must prove, that applicant Mshe made a decision that purported to be in terms of section 1795B of Act 108 of 1996, i.e. by setting aside the decision of Advocate McCarthy and ordering that prosecution against the respondent be stopped. Now, in submitting what I'm submitting, I am not detracting from my submission that this honorable court cannot review a decision. This honorable court can only review an order made by the NDPP exercising his powers in terms of section 1795B.
You've made that submission, and you are saying it did not make an
yes.
order. Are you also saying that the decision by the DPP stands because there's no order?
No.
So just answer me on that.
No, I'm not saying so. I now make the submissions on the following. I'm submitting that if the court finds that there was an order, or if the court says there's no order, now I want to answer this very question raised by Judge Withdrawal. What if it is a decision? But before we go and determine whether it is a decision, let's see if Advocate Mshe made any decision at all. I want to show this honorable forum, this honorable court, that the applicant who bears the onus has not given one semblance of evidence that Advocate Mshe in fact made a decision in terms of section 1795B. I want to show the court that a decision, it is not me who's alleging it. The applicant does not say, stop a decision. I want to review the decision of Advocate Mshe made on this date in April 2009. No, the case before the court, the motion, the notice of motion is not amended. The affidavits are not amended. The applicant says its relief it is seeking today is to review a decision made by Advocate Mshe to discontinue the prosecution of the Honorable President Zuma. That's what is being sought for. Okay. I'm going to show the court now that the applicant has failed to allege, and in failing to allege, applicant has failed to prove that such a decision that it wishes to have reviewed has ever been made. Why I say this is the following. I refer you judges to page 4 of the oral submission that you writing. The reasons hereunder debunk the applicant's submission that Advocate Mshe SC made a decision to discontinue prosecution of the third respondent. Judge, the powers given to Advocate Mshe are exclusively the power to review. Nowhere in any law is Advocate Mshe given the powers of a court to vary or substitute the decision that he would be required to either confirm or set aside. Our courts are given this jurisdiction in terms of Section 8 of PAJA, which says only in exceptional circumstances may a court substitute or vary the decision of an administrator. Advocate Mshe is not. Now, Advocate Mshe's power to review. What is the law that Advocate Mshe must be guided by or is prescribed to follow in making the review? Advocate Mshe, as I've shown the court from Constitutional Court Authority, can only do a review in terms of PAJA. Okay. Page 5, paragraph 2, Judge. Applicant does not even disclose the identity of a person who instituted a review. An indispensable requirement to trigger review is set out in Section 6.1 of Act 3 of 2000. Judge, I showed the court clearly that the review today, which the applicant is asking for, it cannot ever be based on the principles of legality. Why? Judge Brown says it is only the decision of a DPP that can be reviewed in a court of law, not NDPP. Now I suspect the applicant will tell the court, guarantee 1,000,000%, no, we are here in terms of PAJA. I say with respect, no. If you're here in terms of PAJA, then an indispensable requirement for you to follow that's peremptory is compliant with Section 6.1 of PAJA. Where is that compliance? From whom did the DA ask reasons? If the DA asked reasons to Advocate Mshe, the Honorable Advocate Mshe SC, but very nicely, politely, address him properly, Advocate Mshe SC, dear sir, Ray, decision made on blank date. We wish reasons from you to give us why you have decided to discontinue the prosecution of the Honorable President Zuma. Now, if the DA did that politely, very politely and courteously, I reassure you, Advocate Mshe would have sent a response. So, firstly, I made an announcement. Secondly, I made no order in terms of Section 179. Thirdly, you say I did wrong. Okay, if you say I did wrong, I could give you advice, which I'll come to shortly, but you do what you have to do. Section 6 or Advocate Mshe could have politely told the DA, gentlemen, guess what? I agree with you. You say the procedure I did was wrong. I'll do it correctly. But compliance with Section 6.1 of PAJA is an indispensable ingredient to properly obtaining a relief in terms of PAJA. I want to emphasize PAJA, that's the Protection of the Administrative Justice Act, was enacted in deference to Section 33 of our Constitution.
Mr. Omar, I see you are on page 5 and in your oral submission to page 12, and you are left with 10 minutes. I've given you 45 minutes.
Judge, no compliance with Section 6 of PAJA, no compliance with Section 8 of PAJA. Then I continue. No person was able to institute such review proceedings. This is the most important, Judge. Judge, I submit no person was able to institute such review proceedings. Which review proceedings? The review proceedings in Section 179. Simply because there remains no procedure even today prescribing procedure to institute review proceedings in terms of Section 179. Rule 53 is the vehicle of procedure required for a review in the High Court. Judge, in R versus Killick, 2011 EWCA CRIM 1608, this is decision from English authority, found that the right of victim of crime to seek a review of CPS, Crown Prosecution Service, the equivalent of our NDPP, not to prosecute are the following. 1, a victim has a right to seek a review in such proceedings. No question about it. A victim has a right to seek a review to a decision not to discontinue a prosecution. Who's a victim? We have to establish who's a victim. The offences dealt with in English law, assault, rape, murder, etc. Whether the DA is a victim, if the DA says we are a victim, we are a member of the public, my submission is please submit to democracy. Majority don't believe a sitting president should be prosecuted. A victim should not have to seek recourse through judicial review. This is the latest case on point in the UK. Many cases were given to the court. This, I emphasize, I want to impress upon the court, is the latest authority from England on point.
Will you give us a copy?
I will try, Judge, but...
Now, please make a copy available to us, because you should know that when you refer to a case...
I'm arguing for the freedom. Thy friends thy have and the doctrine tried. Grapple into your soul the hoops of steel. I will ensure it gets to your register, Judge.
Thank you.
A victim should not have to seek recourse through judicial process. In England, it is said, a victim who has a right to review does not have to be forced to come to court. Victims' right to review should be made subject to clear procedure and guidance with time limits. Now, Judge, we are 21 years into New South Africa. But this position took about 40, 50 years in England. We are here today. I will ask the court, number one, dismiss the applicant's application. The costs I'll address later. But I'm appealing to this honorable forum. I want the court in its judgment to emphasize the importance of the NDPP to please get moving. Make the rules for the procedure. You can't give a person a right in terms of Section 179 to review a decision not to prosecute and not make accompanying rules. We need these rules. So if the court in its judgment spells out as they did in England, in UK, we need real rules of procedure. Then I will recommend to Sean Abrams, the NDPP, amongst the rules will be the following. Number one, a sitting president cannot be criminally charged. Neither can a decision to discontinue prosecution against a sitting president be entertained. Number two, a president who has served a term in office, completing his term in office, can under no circumstances have subject to review a decision to discontinue prosecutions against him for actions he took before he became president. Two rules I've suggested today. Applicant, I submit, misleads this honorable court by suggesting that Advocate Mshe made a decision in terms of Section 179. Judge, to summarize this point, I am showing the court a decision. Advocate Mshe could not make the decision or order in terms of Section 1795D as alleged by the applicant for the simple reason that there is no procedure. It's impossible. You know, if I may use an analogy, I'm saying, please get to destination called Kathmandu. There's no road built to Kathmandu. How can it be suggested that Mr. Valda, the secretary, went to Kathmandu? There's no road. And we can only get to the place by road. Impossible. Then I submit that Section 5 is also a necessary ingredient to invoke successfully the relief suggested, contemplated in paragraph. Section 5, Section 6. There is no allegation that there was compliance with Section 5, 6, or 8 of paragraph. These are necessary allegations which the applicant was required to make. It's nothing of the sort. I mean, we in motion proceedings, if you allege there was a decision, I've shown you this is out, but in any event, if you allege there's a decision, Mr. Applicant, you must prove it. In motion proceedings, you allege and prove. But if you haven't alleged these essential ingredients, how can you say to have proved it? Impossible. I've sufficiently addressed judges on my submission that this honorable court does not have the jurisdiction to grant, I want to emphasize, to grant the relief paid for by the applicant in this case. Never. Judge, I want to emphasize on this point. These are my instructions. Suggestions to the contrary undermine the supremacy of the South African Constitution and the sanctity of the principles of separation of power. Judge, you know, in Kudesa, we struggled. The previously privileged wanted certain protections. We agreed. Ours was not a military victory. Our country was a negotiated settlement through the sacrifices of Madiba and President Zuma, who was the head of Mkonto. They sacrificed their lives for us. The principle of the sanctity of the separation of powers to us is as sacred, or could be as sacred, as the Quran is to me. We'll die for this. The independence of the judiciary, the executive, the prosecuting authority, and the bureaucracy must remain firmly independent. What is shocking is that the applicant who purports to want to uphold democracy, uphold the Constitution, wants this court to do the contrary. This, Judge, is analogous to asking the Constitutional Court, which happened recently. There was a case in the Constitutional Court, and a counsel asked the Constitutional Court to pronounce or make findings involving a phantom, non-existent impeachment proceedings. How can the Constitutional Court or any court make findings about impeachment proceedings which are the exclusive preserve of Parliament? So this is the extent which the applicant wants us or wants to contaminate our law, our jurisprudence. So we should move into an era where we have no more distinction between separation of powers. What's the aim? The aim, ultimately, govern the buggers through the courts. That's the aim. That will not happen. That will not happen. Judge, furthermore, I emphasize, if the majority of the electorate were unhappy about the discontinuation of the proceedings against the Honorable President Zuma, such dissatisfaction was clearly not manifested in 2 democratic elections, resulting in Honorable President Zuma serving his 2nd term as President of the RSA. The most recent attempt was yesterday, a vote of non-confidence. Applicant attempts to distort the SA Constitution. I want to emphasize, the applicant attempts to distort the South African Constitution, which is sacred to the hearts of the stalwarts of the struggle, by undermining the will and intellect of the majority of South Africans. Mine too. This is startling, as there is no democratic country in the whole world with an official opposition attempting to have a sitting president prosecuted, even before ending his term in selflessly, and I want to emphasize, very stoically, serving the majority of the people. President Berlusconi, they tried it. The court ordered, the highest court in Italy ordered, you can't prosecute him now, wait till he finishes his term in office. But the goal to come to the court and to add burden to our president, good Lord, what is serving in office? What's the purpose? Judge, now, with respect, the proceedings in the KwaZulu-Natal High Court.
Mr. Omar, your time is up. Please summarize your submissions.
I'm the last page.
Okay.
Judge Motley and Judge Withdrawal asked a question to my learned friend, Advocate Kim. My instructions are that in Pietermaritzburg, KwaZulu-Natal High Court, when Honorable President Zuma was called as an accused, the state asked for a postponement. The learned judge who was presiding at the time, Msimang, refused the postponement. Judge Msimang looked at the prosecutor. Prosecutor did nothing. Judge Msimang then struck the matter of roll. So that is the state of the proceedings against the Honorable President Zuma. It's not an order or a decision to discontinue proceedings. It's the striking the matter of the roll. Right. Now, I will tell the DA what to do. And they do it, I'll bring them again. What the DA, the applicant, ought to do is the following. Bring an application for a mandamus, do a letter to the NDPP, Sean, say the case is pending, pa. The court struck the matter of the roll. You must set the matter down. If the NDPP refuses, the DA eagerly brings in a mandamus to compel. Court may grant mandamus. Court grants mandamus, and all these arguments here will be dealt with in the KwaZulu-Natal High Court. How can this court be asked to interfere in proceedings that are pending? The issue that must be answered today is what is the status, what is the effect of a striking out order. In conclusion, Judge, if this honourable court agrees with me that the sole motive of the applicant is to extract a pronouncement of adverse infighting within the leadership of our ruling party, the time has come for us to send a message loud and clear to the applicants. Stop it. Stop interfering with the Constitution, and therefore I'll ask the court, if the court agrees with my submission, make a cost order today on the attorney and own plan scale, jointly and severally, they warning is pro police against the applicants. First warning today. Next warning will be something else. My neighbor become president. Who knows after 100 years? But another a firmer warning. Thank you, Judge.
Thank you, Mr.
Thank you very much, Judge.
Mr. Rosenberg, surely you need to reply. Can you give us an indication as to how many hours are you going to need with your reply?
I would welcome an opportunity to commence the reply tomorrow.
Yeah, it will definitely be tomorrow. We just wanted to have an idea of how long.
And making it brief. I certainly don't anticipate that I would be much longer than an hour.
No, thank you very much. I think we'll adjourn and then.
Sorry, Judge, Judge, I have a medical condition. My feet get very warm. It's being aggravated. Will the court excuse me from tomorrow's proceedings? I'll ensure a representative of my client is at court.
Yes, you'll be excused in respect of tomorrow's proceedings. So the court will adjourn. Will start again tomorrow at 10 o'clock. Thank you. Court adjourned.
Come here, my friend.
If I'm a judge, I'm in debt by now. This kind of question. Thanks God, I'm not a judge. Where to start? This guy's doing in all directions. I see a You think this boyfriend will agree? Just hijack them because which yes. It's only these people. What if they were trying to move and then they pack it in another state?
No, just for this week.
Pretend as if you don't know because it will turn out to be some for now, yeah. You guys, they are sabotaging us, they are discriminating.
No, but you know, I need to learn as a seventh avenger. These people have got a very serious matter. I need to get you have got package.
Yeah, that's why I need to pretend as if you're given the permission to go on. Before they catch up and then I said I don't know how we ended up there.
Then JP cost me.
It takes long for JP, only can be Nick. Can be me who can swiftly call you.
Oh yeah, let's be the Kagala. Hey,
but what are you doing?
let's give him must remove emote after. I had the revenge.
it's difficult to tell you. Are you still going to take some stuff out this side?
Yeah, we're going out there.
Yes, thanks very much. Hello. I trying to push back Kimotol, trying to push back Kitsit. I got to see if we put my level too late. Let me know what CD and my make that she would. So it's working till late, and then we can allocate based on that. Or else even now. If we,
No, like the they are talking now they just took my car. So now they said for me to use and then they came up with the and then another thing, I mean, there's a problem there.
so Pima was issue the money.
But they were internet, but then they went to the house.
When I didn't really charge for that, okay, the charge of something.
And I don't know how to the front of the police because the police is
Now in front of the police,
no, get another place somewhere. So when I'm going to
We've given them enough.
Antoinette, I don't think it's going to be too much. Maybe if you can escalate it to JP, no to Antoinette. Because it's only from the JP to say, yes, officials, they can park in the palace. That's what. Because to park this side, it's not a problem. But it's a problem, they shouldn't park it right. Because if you park it now, I told you, but my father will take it everything.
yes, that's what they did there. Now I told them that.
Manje bona bathi yenza njani manje?
Bathi ngizele something support.
Wena ukujaja.
Ujasho khona manje bathi ngizele something sokuthi ngibonise ukuthi ngiyo-official yala.
Oh, I understand. Leyo uchuthi yana
And then kuba kwa-Antoinette and abatshela ukuthi bengisekhona.
yeah, Antoinette yabayenza ukuthi sort of would here pay or a certificate so and so is an employee of the High Court and then employee number 1, 2, 3 then listed as an issue. It can be
Ngoba khona manje bafuna 1,000 something. We can't live like this. It's not fair.
we can't. With every day, we have to go.